ready to go on the record? Let's go on the record, please. Good morning. This is the time and place noticed for a hearing in the formal complaint under Schedule 38 of Clenera LLC on behalf of 1.21 GW LLC against Rocky Mountain Power. That's Commission Docket number 17-035-52. My name is Michael Hammer, and I am the Commission's designated presiding officer. Let's go ahead and take appearances, please. We'll begin with Rocky Mountain Power. I can. Are you picking her up, Sherry?
Is that better?
Much.
Okay. Good morning. My name is Yvonne Hochul, and I'm here on behalf of Rocky Mountain Power. With me here today are Mr. Mark Tourangeau, who is the Director of Commercial Services, and Mr. Brian Fritz, who's the Director of Engineering. On the phone, I believe we have Mr. Rick Vale, who is Vice President of Transmission, and Mr. Chris Bremer, who is Manager of Generation Interconnection. Thank you.
And the complainant.
Jim Barkley, Baker Botts, representing Clenera Energy. I have with me Jason Ellsworth and Dustin Shively from the company. Want to let you know that I am licensed in Texas, not in Utah, but have with me the certificates of good standing that are required to allow me to be present today and represent my client.
Thank you, Mr. Barkley.
Good morning. I'm Justin Jetter with the Utah Attorney General's Office, and I'm here today representing the Utah Division of Public Utilities. And with me at council table is Charles Peterson with the division.
Are there any preliminary matters before we begin?
Just one question. Mr. Barkley, do you also have the admission pro hoc vice from the state of Utah to practice here?
The new rules do not require the admission pro hoc vice for out-of-state attorneys. They simply require that you present the commission with a certificate of good standing from the state bar.
Okay, thank you.
It is a new rule. It's not even codified yet. It became effective, I believe, in October.
Thank you.
You're welcome.
With that, we'll go ahead and proceed. Mr. Barkley, are you prepared to call a witness?
We are, Your Honor. We would begin by calling Mr. Dustin Shively.
And does counsel have any preference as to whether witnesses take the stand? With this many, it might be easier.
I'd be delighted for him to take the stand, actually. I think it's probably simplest.
Okay. Please, Mr. Shively. Mr. Shively, do you swear to tell the truth? Yes. Thank you. Go ahead, Mr. Barkley.
Mr. Shively, by whom are you employed?
Is this Clenera LLC?
Okay. And what are your job responsibilities and your job title at Clenera?
I am Director of Engineering, and I'm responsible for all of the technical oversight for our projects in development, construction, and operations.
Okay. And could you describe for the commission the projects that are at issue in this case?
The projects that are at issue in this case are 14 80 megawatt AC projects located in Utah County, solar PV projects.
And do the two sets of projects have names that are commonly used?
Yes, the Faraday, there's a group of 7 called the Faraday projects, and the other group are called the Goshen Valley projects.
And when was we'll just like to walk through with you the timeline of events in the case. When was the first request from Clenera to Pacificor for indicative pricing for the Faraday projects?
The first request for the Faraday projects for indicative pricing was November 2nd, 2016.
And when was the first request for indicative pricing for the Goshen projects?
November 15th, 2016.
Were there any subsequent changes to those requests?
Yes, we later in December we had a larger batch of projects in the Faraday projects that originally went in for pricing, and we withdrew 7 of those because we had different online dates, and we decided to not proceed with those projects. And on the Goshen Valley projects, we later changed the point of interconnection. The site remained the same, but there's multiple lines that cross the property, so we swapped from one line to the other line and changed the points of interconnection.
Did the changes that you made in December of 2016 affect the deadline for the indicative pricing on the Faraday projects?
Yes, those the original when we removed 7 projects from the list, the other 7 then were repriced or sort of they maintained the same queue position in the pricing queue, but the pricing was recalculated.
Did it affect the indicative pricing request for the Goshen projects?
No, those ones were still under the same procedure.
When did you first receive indicative pricing for the Goshen projects?
The first, and I believe we received the first Goshen Valley pricing on December 22nd, 2016.
And when did you receive the first indicative pricing for the Faraday projects?
January 17th, 2017.
Were those the final indicative prices for both of the Faraday and the Goshen projects?
For Faraday, yes. For Goshen, no. Because that change in the point of interconnection, we received new pricing for Goshen later in 2017.
When did you make that change to the interconnection point for Goshen?
February 1st, 2017.
And how did that affect the timing on new indicative pricing for Goshen?
That reset the 30-day clock for Pacificor to provide the pricing.
And did Pacificor indicate to you when you were likely to receive that indicative pricing?
They did. Just a correction, clarification, after the change in interconnection was made?
I'm sorry, after the change in interconnect, yes.
That would be delivered to us within the 30-day period in early March.
Okay. When did you receive the revised indicative pricing for Goshen?
On March 16th.
Have you had an opportunity to review the October 23rd response and motion to dismiss that was filed by Pacificor?
Yes.
And have you had a chance to review the October 23rd response that was filed by the Department of Public Utilities?
Yes.
In the response filed, the response from the Department of Public Utilities on page 3, there is a discussion of some of these dates involved with indicative pricing. Did you find the dates in that discussion to be accurate?
Yes. A lot of the discrepancies, as far as we're talking one day here or a few days there, has to do with the fact of when the request was made or when it was deemed complete. But by and large, yeah, all of the dates are consistent with our timeline. Just a few differences here or there on when emails were, exchanged, considering when the request was made or when it was deemed complete, those kind of things.
Has Clenera made a request for form PPAs?
Yes.
Okay. And when was the request for a form PPA for Faraday made?
On March 13th of this year.
Okay. And when was a request made for a form PPA for Goshen?
On May 12th of this year.
And is it your understanding that both of those were made within the applicable deadlines?
Correct, yes.
Okay. Did you receive any confirmation from Pacificor as to the completeness of the PPA request for Faraday?
Yes. It was communicated from Pacificor that our request was complete.
Okay. Have you received a similar confirmation regarding your request for a PPA for Goshen?
I would have to confirm because right around that time is when the conversation was continuing on Faraday. So Goshen, the confirmation sort of got lumped into the discussion on Faraday.
Okay, and when you say the conversation on Faraday was continuing, what are you referring to?
I'm referring to whether or not we needed to provide a completed interconnection study to receive a draft PPA.
And did Pacificor indicate to you that you needed a completed interconnection study in order to get the form PPA for Faraday?
Pacificor communicated to us that we needed a draft interconnection study through communicating with them, but not in the tariff is that communicated.
When did they first communicate that to you?
That was April of this year. April 18th is the note I have when that was first communicated that we would need a completed interconnection study to receive a draft PPA.
And again, does your understanding of the dates on which requests were made for form PPAs match the discussion of those dates in the response that was filed by DPU on October 23rd?
Yes, more or less the dates for when we requested PPAs are consistent, minus any day here or day there difference.
Has Clenera requested an interconnection study for Faraday?
Yes.
Have you requested an interconnection study for the Goshen projects?
Yes.
When did you request those interconnection studies?
The initial interconnection requests, or the interconnection requests, were November 29th of 2016.
Okay. And have you received any communication from Pacificor deeming those requests complete?
Yes, the requests were deemed complete. We exchanged, there's of course some back and forth on the technical aspects of the project. We had a scoping meeting, which is the preliminary call before a feasibility study agreement. We then received a feasibility study agreement and executed it.
And when were the feasibility study agreements executed?
On February 15th of this year.
And was that for both Faraday and for Goshen?
Yes, for both.
How long have you yet received an interconnection feasibility study from the utility?
We have not received a feasibility study yet.
What is your understanding of the usual timing for an interconnection feasibility study?
The usual timing is about a month. The FERC guidelines in the large generator interconnection procedures is 45 days.
Do you recall what the utility's tariff says will be the timeline?
The tariff says it's a 45-day feasibility study.
And I have no further questions for Mr. Shively, Your Honor.
Thank you. We'll begin with Ms. Hogle. Any cross?
It depends. I would like to know if Mr. Ellsworth will be available as a witness.
Mr. Ellsworth will also be available as a witness.
I had intended to cross Mr. Ellsworth, given that his name is on the pleadings that were filed in the case. I don't know if that would be okay with you, or if we can ask your current witness.
And I really am not trying to be obstructionist. If there are questions about dates, Mr. Shively is probably the better witness. I'm happy to tell you now that that the testimony that I will elicit from Mr. Ellsworth is really going to involve the timing of QF status, the relief that's requested by the company, and the basis for that relief. So to the extent that the questions involve those subjects, Mr. Ellsworth is absolutely the most appropriate of the two witnesses. To the extent it involves dates and timelines, Mr. Shively is probably the better of the two, although Mr. Ellsworth is familiar with much of that information as well.
If Mr. Shively plans to stay around, I'd be happy to allow Ms. Hogle to call him when the company puts on its witnesses, if he'll be present.
And that's fine with us, Your Honor. I am happy to proceed however you would like. That was just to sort of give you some background on how at least we view the two witnesses and their subject matter.
Sure. I guess I'm hesitating a little bit because typically the witness on the stand would adopt the pleadings that were filed by a party. And so I'm not sure if Mr. Ellsworth or Ms. or
Shively.
yes, Shrively is adopting the pleadings that were filed and signed
Well-
by.
We'll have
Mr.
Mr. Ellsworth
Ellsworth.
adopt them.
Okay. Thank you. Then I will wait for cross-examination.
Thank you.
Thank you.
Mr. Jetter.
And I have no questions. Thank you.
Thank you, Mr. Shively. Mr. Barkley.
And with that, we'll call Mr. Ellsworth.
Thank you. Mr. Ellsworth, do you swear to tell the truth? Thank you.
Mr. Ellsworth, can you state your full name? And by whom are you employed? What is your title at Clenera? And what are your responsibilities there? Have you been involved in the preparation of the pleadings that have been filed in this case by Clenera? And are you in a position to adopt those as your own testimony? Okay. Have you had a chance to review Pacificor's filings as well?
Yes, I have.
And how do you respond to the criticism in those pleadings that Clenera has not filed its Form 556 at the FERC to obtain QF status?
It is typical for us and other developers to file 556 at a point that is closer to the actual commercial operation date of the project. In fact, we completed a project in southern Utah with Pacificor recently, where the 556 was filed just shortly before our commercial operation date. The reason for that is the 556 identifies certain structural ownership elements of the project that may not be finalized and fully determined until late in the build cycle.
Is it your understanding of the utilities tariffs that Clenera would be required to have obtained that QF status at this stage of the interconnection process?
No, that's not our understanding, and it's also not typical of tariffs generally in the world that we participate in this utility scale solar world.
Do you have are you familiar with what the Rocky Mountain Power tariff does in fact require with regard to QF status?
Yes, I am.
And what is that?
So that the requirement, as I understand it, is that we show that we are eligible, that we are eligible as a QF. And in fact, the interesting component of a 556 is it's a self-certification anyway. So it's not something that we look to FERC for their judgment or rule. It's rather we self-certify at the time and place that that's necessary.
How do you respond to Pacificor's claim that the delay in processing Clenera's interconnection requests is justified by an increase in interconnection requests across the Pacificor system?
I'm surprised by the assertion. It is not consistent with the data that we have reviewed that is publicly available on the Pacificor Oasis system, their real-time system. After seeing their assertion that that was a limitation on their side, we pulled up at the time of their motion to dismiss the actual data on Oasis and see that in fact there has been a relatively consistent drop in the number of applications since 2013 here in Utah. To a very small number relative to other utilities. There's a very small number of applications that are being processed and handled by Pacificor for Utah. For Pacificor in total, because I think they handle these applications not on a state-by-state basis, but across their systems. The applications rose in 2015, but have been relatively consistent thereafter, with a small bump from 15 to 16, but have been relatively consistent thereafter.
Did you present data on the volume of interconnection requests in your October 24th response to Pacificor's motion to dismiss?
We did. We presented that data. We thought it was important to answer the assertion that that was a cause for the delay with the data that is available online and direct from the company. And that data does indeed show that there has not been a significant climb in applications. Back in 15 to 16, there was about a 30% increase, and that and we've struggled to see how that ties to a delay in terms of the study process, which is scheduled for 45 days, to go from 45 days to the approximate year right now that is anticipated by Pacificor.
Mr. Ellsworth, what relief does Clenera seek in this proceeding?
So we are seeking for relief under the tariff as it relates to the deadlines. The tariff allows for an extension in the case that the company delays, and we are looking at these company delays and requesting that we receive a day-for-day extension on developer deadlines associated with the tariff as it relates to the company's delays. Right now, the delays are we're approaching a total of a year on a 45-day project or 45-day study, and we based on the existing on our previous experience, expect that those delays may exceed that as it relates to further activities with the company.
What are the specific deadlines from which the company is seeking relief?
So specifically, to call out two deadlines that are important to us is the first deadline in which we are to have a PPA executed between developer and the company within the 6 months following the receipt of indicative pricing. In addition to that, we are looking for overall extension and delay as it relates to our online date. As Your Honor may be aware, the tariff calls for a 30-month limitation in terms of when we file for pricing. We must indicate that our online dates are to be within 30 months of the timeline allowed for a PPA. So at the time of our filing for the pricing, we could date these projects no later than the end of 2019. That timeline limitation has made it very difficult, as we've seen and have now seen a year of our processing time disappear. So that's 365 days on the first study versus what is in the tariff, which is 45 days, making it very difficult for us to perform in that timeline. Therefore, we're asking for an extension, an overall extension to those dates as well, to those online dates.
Mr. Ellsworth, you're familiar with the Department of Public Utilities response that was filed on October 23rd, yes?
I am, yes.
And you've seen the concerns that they expressed regarding the extension of the operation date.
Yes.
Yeah. Could you address those concerns?
Yeah, I think overall if you review I think the overall concern was pricing and relevance of pricing if those dates are extended. The challenge is trying to draw. The challenge that's been highlighted is whether or not those prices are relevant in an extended situation. The reality for us, and based on the numbers that we've received and our review of the IRP, is the forecast for Pacificor is rising prices over time. So the further extension of of our timelines, had we been given time to greater than the 30 months in light of the time that Pacificor takes on their side, those prices on those PPAs would have been higher. Right now, those prices are in fact at a very competitive level. We believe that in fact we are in a position to hold to those despite the ups and downs in the markets and the difficulties in delivering, but have spent a great deal of time and energy as a company at the exclusion of other opportunities that we could have pursued to pursue these projects for the benefit of ratepayers. We believe that the avoided cost calculations are an accurate way of identifying what the impact is to the ratepayers, and that these projects are in fact beneficial to ratepayers. I think that Pacificor can identify, or I'm not sure what's appropriate in this environment to identify those prices, but they're very, very competitive prices in the context of energy in general, not just solar.
How does the timing of Pacificor's handling of these interconnection requests compare to the handling of interconnection requests that you've seen in other projects done with Pacificor and with other utilities?
So our experience with Pacificor is limited. We have one project that is operating 80 megawatts, the size of one of these typical projects in southern Utah, and then have run quite a number of other projects through the process here with Pacificor, identifying across their system where there was opportunity, where there was interconnection capacity, and where it made sense from a load proximity basis to deliver power. We in that process have identified what appears to be, I think, historically a process that's been relatively responsive, but of late one that is significantly delayed without a necessary commensurate sort of set of applications to justify that. That said, our review with them is on the reasons for those delays has resulted in explanations that they are pursuing a serial process, which means as they review each project, one drops out, they have to go back and review all of the projects again. That is the most inefficient and slowest of all the processes that we deal with in the utility scale world. What is typical in the case where there are a significant number of applications is that those applications will be handled in a cluster process and studied together, and then there is often in that case an ability to deliver. In fact, typically an ability to deliver within roughly the 45-day timeline. Whereas here on the Pacificor side, the decision's been made to continue to pursue a serial process, and that serial process has resulted in delays beyond anything that we have experienced elsewhere across the United States. We also see that in general, the number of applications that Pacificor has seen is de minimis as compared to the number of applications other utilities have seen in California and elsewhere. Those processes in other locations have continued to operate within a reasonable range of that 45-day period. Whereas here with Pacificor, it's not a minor extension from 45 days to a few maybe 60 days. It's 45 going to 365 days, and that's been an unusual experience for us, and one that we think is markedly different from the market and the rest of the industry.
I have nothing further from Mr. Ellsworth, Your Honor.
Thank you. Ms. Hochul?
Thank you. I guess I'll start with what you just mentioned as being the typical process that you're used to, can you provide the basis for that testimony?
Yeah, so we have, as a company and as individuals have been in the development space and working with interconnection and projects for the better part of a decade, and in that process have made hundreds and if not thousands of interconnection applications, and worked through that process with various utilities, mostly in the West, but also in the southeastern United States. So with that, I would say the number of utilities that we've worked with it exceeds 40. And so the sample size is relatively large, both in terms of applications and running through that process, as well as actual utilities that we've interfaced with.
Okay, thank you. I want to take you to the reply that you filed on behalf of Clenera. Do you have it with you?
I don't have it in front of me, no.
Okay, so if I were to ask you questions in that reply, would you, could I jog your memory for you to be able to respond to my questions?
I'll do the best I can.
Okay, thank you. So,
And Ms. Hogel, are we referring to the October 24 reply?
we're referring to Clenera's reply to Rocky Mountain Power's response. So, in the first page of that reply, I believe you stated, given that you signed the pleading, Pacific Corp gives no reason for their last-minute change in position, and I believe that you were talking about the extension that we're talking about here. Is that correct?
Yeah, in fact, I think the reply is in the context of Pacificor originally was very clear about supporting our effort to extend. In fact, noting that they had made a decision internally to extend, and due to their own delay as the company, that was the subject of conversations with Kyle Moore at Pacificor. Later on, Kyle Moore came back and indicated that on discussion with the Department of Public Utilities and the Consumer Services, that they were advised that they could not do that, and that the company therefore had determined that that was not possible. But had it been, they were still in support of. And yet they were unable to proceed because of limitations of these other agencies. So when I said that the company had changed their position, that is so the motion to dismiss was a very different tact than them supporting our effort to make an extension. And in fact, in that motion to dismiss, they referenced another docket that was filed before the commission with S-Power. In fact, where they cited these very delays as delays which were a reason, these kind of delays, as delays for which it was a reason for them to extend the process, extend the deadlines. So taking that different tact with us and opposing that, I view that as without explanation and without context in terms of the communication.
Thank you. I'm also going to reference your complaint that you also signed. And in that complaint, in the last page, you state, approximately 2 weeks after the meeting and discussion of Pacific Corp's proposed solution, developer received the following communication from Pacific Corp. And I quote, "After further review and discussions with the staff of both the Division of Public Utilities and the Office of Consumer Services, The position of Rocky Mountain Power is that delays caused by Pacific Corp transmission are not contemplated as RMP delays and should not extend the timelines in the scheduled 38 tariff, excuse me. Isn't that a reason that you stated in your complaint?
So that's consistent with the facts I just referred to, in that Pacificor had turned to the DPU and Consumer Services and indicated that their lack of support for this and their opposition it was a cause for them as a company to change directions, and so that's consistent in terms of the direction, inconsistent in terms of the sentiment that was expressed by Pacificor.
And so, given that Pacific Corp and you yourself quoted a reason for a change in position, that is not consistent, is it, with what you said in your reply when you said Pacific Corp gives no reason for their last-minute change?
When I noted their last-minute change, I wasn't noting that that they were that they were looking to different reasons. I was noting that that Pacificor was changing their sentiment, in fact saying that their perspective was this was not something they had supported at all, which in fact was not true. From the beginning, Pacificor was in support of an extension. Their history has been to support extensions in the case that the delays were caused by the company, so the sentiment had changed.
Okay, but unlike or contrary to what you said in the reply, that Pacific Corp gave no reason for this last-minute change on the sentiment of the extension. In fact, in your complaint, you actually quoted Pacific Corp's reason. So there was a reason that you yourself quoted in your complaint. And so that would be inconsistent with your reply that there was no reason, correct?
I disagree. I think you're speaking to rationale for the reasons for making a decision. I'm speaking to the sentiment behind the decision.
Okay, thank you. Going back to the reply that you filed, and your claim that Pacific Corp's behavior in this matter results in economic harm to stakeholders. Do you recall that?
Yes.
Okay.
Yes.
Are you aware of the approved term for a power purchase agreement in Utah?
I am very aware of the approved term for a power purchase agreement in Utah.
And what is that?
It's right now for projects of this size, it's 15 years.
Okay. Are you aware of the fact that Pacific Corp passes through its energy costs to its customers in the state of Utah?
Yes, I'm aware that this is rate based.
And that's 100%. Are you aware of that? Subject to check. Would you agree that it's 100% pass through, meaning customers ultimately pay for the avoided cost pricing that you are provided?
Correct. I'm aware that avoided cost is supported by customers.
Okay. And so Clenera is seeking a power purchase agreement for a term of 15 years. Is that right?
That is correct.
And isn't it true that the commercial operation date has an impact on avoided cost pricing?
It does. As I've explained, the commercial operation date, the further that it's pushed out, is typically the higher. So it does have an impact on pricing.
And so if Pacific Corp doesn't know whether Clenera can meet that commercial operation date, the avoided cost pricing may not be accurate, correct?
If it is correct that if the timing changes, the pricing calculation would be different at the point of calculating that pricing. Yes.
And so isn't it reasonable for the company to require that information prior to that information, meaning the commercial operation date, prior to providing a power purchase agreement with avoided cost pricing that would be locked in for 15 years?
It's entirely reasonable, and in fact, it's a similar process that's pursued in many other utilities. Those timelines are important to both the utility and the developer.
And so whether the prices are high or low is really not relevant. What's relevant is that they be accurate. Would you agree with that?
I think that when you're talking pricing and timing, both are very important, and both parties need to be able to rely on timing. Timing is critical to these projects. So, in fact, we are entirely subject to and reliant on the timing that's provided in the tariff, on the timing by way of commitments that are made by Pacificor. So, as the company delays, we have no other recourse than under the tariff to look for extensions. But yes, the timing is important.
And the pricing, the accuracy of the pricing is important, correct?
Pricing and timing are tied, absolutely.
Okay. All right. And so if the company locks in a PPA with a QF for 15 years and the pricing is not accurate, that would be an economic harm to its customers, wouldn't it?
I think you just made a intellectual leap between accuracy and economic harm. Economic harm would presume that the pricing were in fact higher than it would have otherwise been. I think that had there been at that time a clear understanding that Pacificor was not going to perform within the timeline that was provided, that in fact we could have gone to a later date to accommodate the Pacificor timing. I think in fact the pricing would have been higher. So that's consistent with the pricing that was received. We got pricing for a 2018 project. We got pricing for 2019. 2019 pricing was higher, and that's consistent with the IRP, which leads me to the conclusion, if we are to make conclusions, that in fact this would have been an economic benefit to ratepayers to take a later date versus the original date. And judging this process based on current timelines that have been imposed and created by Pacificor's lack of performance is a mismatch with what is originally and most importantly a process whereby we are given pricing based on the timing and the conditions at the outset of the project.
And economic harm can result not only if prices are higher, but also if prices are lower than they should be, correct? Because if you lock in if you lock in a contract that is lower in prices, for example, then economically it might not make sense because for 15 years those prices are locked, and given the length of the contract, the point is that the pricing should be accurate, not lower, not higher, but accurate.
So I think the discussion about economic harm for higher or for lower prices in the context of rate base doesn't tie to my experience in mathematics and economics. It's the lower the price, the more the rate base, the consumer benefits. Whether or not we as a company are able to deliver at that price is our responsibility. The tariff doesn't speak to that. The tariff speaks to pricing and timing and a process whereby the company and we as a developer are tied together in a process to deliver a product at a given price. And that price If it is lower for the consumer, that's ideal, and that's something that we strive for as a company.
I have no further questions. Thank you.
Thank you. Mr. Jetter.
Good morning. I do have a few questions. I'd just like to sort of clarify a little bit with something that you had stated in your cross-examination, and I believe also potentially in your direct testimony. Is it accurate to kind of rephrase what you had said a few minutes ago, that your basis for understanding that a later interconnection date would potentially have a higher price was due to a repricing that changed the online date early in the project, and that gave you a slightly higher price?
No, it's not due to the repricing. So we originally submitted for both 2018 and 2019 prices, and on the repricing pushed our 2018 back to 2019 to the point of, with respect to economics, we determined the economics were not favorable, were not attractive for the 2018 timeframe. We also determined at that time that 2018 was not a workable timeframe within the process that is allowed here. But those prices came out showing in fact a rise in price to 2019, which in fact does tie to the IRP and would be expected in the Aurora modeling that takes place behind this.
Okay. So are you aware of any direct connection between the IRP process and avoided cost pricing?
So we're all we know is that this utilizes Aurora. I think that's my understanding, that the Aurora pricing model and tools are used to reach the avoided cost here. The inputs and the information are the same inputs and information, or should be the same inputs and information used in the IRP process. They're both represented to the state and to all stakeholders that are involved in looking at the pricing of energy and in the long-term equation for the utility and for those that participate with the utility.
Would it be surprising for you to learn, or would you accept subject to check, that IRP pricing forecasts have consistently been higher than QF pricing contracts?
It would be, no, it's not surprising in terms of the quantum, correct? That is, I think that is correct.
Okay. And I assume in your capacity and your employment that you follow wholesale market prices during solar hours?
We do, yes.
What would you describe the trend of those over the past 5 years?
So the wholesale pricing, in what market?
Any of the Western hubs that are interconnected into Pacificor's system.
So the Western hubs are, we could spend a lot of time talking about the Western hubs and what's been happening in pricing, but
Just choose, I don't know, Palo Verde.
Yeah, so Palo Verde and others have been impacted by very low natural gas rates. Those natural gas rates have hovered near, have dropped to historic lows. But that follows some cyclical patterns associated with gas. Also advances in technology and other things on the gas side. The other impact has been a push, so say Palo Verde, on the renewable side, where we and others have been successful at driving costs down and continuing to drive costs down. So generating depends on the time of the day, but certain times of the day are actually quite expensive for power, and others are not, based on the generation mix of any given utility.
And so, following up on that, would it be accurate to say that over the past 5 years, for example, the prices during those hours have been trending down?
During the last 5 years, yes.
Okay.
Yes.
And would it be fair to say that a 1-year extension or comparison that you received during your indicative pricing request comparison may not be an accurate reflection of other changes in online date for like the next consecutive year pushing that out?
I think that the reality is that all future pricing is based on forecasting at the time and forecasting based on what limited information one might have. As I understand it, Pacificor, like many of us, has affiliates that also participate in with avoided cost, and that avoided cost is set in a similar process using, locking in on rates based on forecast, based on avoided cost, and a profile that uses the best information that Pacificor and others have, the commission and others have in setting those rates.
Okay, and so just to kind of tie this down a little bit, you don't know, do you, whether extending the online date would have resulted in a higher or lower price for another year?
So had we at the time that we filed been able to insert a later date than the 30-month limitation provides, we having not done it and not having been able to do that, we don't have specific information about it. All we can say is that the underlying information and the profile for those projects, in fact, shows an increase. And I'll revise my statement slightly and say that under Pacificor's tariff, we can take and Pacificor allows us to take an average price, weighted price over that period of time, or a variable price based on their forecast. Those variable prices showed prices increasing over time. So in fact, in a much more detailed way, we can see a profile coming out of that pricing, whether it was our 2018 or 2019, that showed a consistent increase in pricing over time. And even today, we see that in the pricing that is provided by Pacificor. So I would say that definitively we can say that if that same data were used, absolutely we would have had a higher price for a later date. Did we actually get a later date with another price? No, because it's not allowed in the process, and it wasn't anticipated it would be needed.
Okay, just to clarify, you said you can't definitively say that, or you can definitively say that it would have been higher?
Oh, no, I can say that it would have been higher based on the information that was provided to us, yes.
Okay, and so they
But
provided
we did not
information
get the
for
date.
the value of the 16th year?
So they did provide information for the value of, they did not provide information for the value of the 16th year, but they had the trajectory for the full 15 years.
Okay, so you're saying you can definitively confirm today what would have been in the 16th year?
I cannot, no.
Okay, thank you.
No.
That's the only question I had.
Any recross?
Just a couple, Your Honor. Mr. Ellsworth, there was some discussion earlier regarding a reference in Pacificor's motion to dismiss to another docket. I'm looking at page 3 of that motion to dismiss, where Pacificor says, as the company previously stated, in docket number 17-035-13, Pacificor Transmission has experienced an unprecedented surge in interconnection applications, primarily from developers in Utah and Wyoming. Is that the docket to which you were referring? I asked that just to see if that's the right docket number reference.
That's correct. That's the correct docket.
There was also some discussion about whether or not Pacificor had given a reason for their change in position. You remember that back and forth?
That's right.
Okay. When Pacificor informed you that they were changing their position based on meetings with the Department of Public Utilities and the Office of Consumer Services, what actions did you take in follow-up to that?
So we asked for contact information as it related to those agencies, and so that we could follow up and confirm. It took us multiple contacts and then a follow-up in-person meeting before Pacificor provided that contact information. We then, with that contact information in hand, reached out to and made direct contact with both agencies. The first Consumer Services said that in fact they did not, to paraphrase, did not have anything to do with this, and were not would not be involved in or have an opinion associated with this process. And then on our contact with the Department of Public Utilities, they indicated they did not recall ever having this conversation with Pacificor, but in fact had been a part of this recent docket that was referenced by Pacificor in their response. In their motion, and had been successful in extending dates, and that they would generally be supportive if there was a similar fact pattern from the standpoint of delays by the company.
Other than the concern expressed in DPU's response regarding the online date, has either DPU or the Office of Consumer Services expressed to you any concern with your request for extension of, for example, the 6-month deadline for executing a PPA following indicative pricing?
No, they've not, and I think on the note of extension, and I think we understand the concern on timeline and pricing, not knowing what the 16th year pricing would be. We as a company would be very open to an update on that 16th year, whatever that 16th year update would be, but otherwise holding to the pricing that and methodology for the remaining years that were provided to us.
So based on your follow-up actions, your follow-up conversations with DPU and the Office of Consumer Services, did you conclude that Pacificor had provided any compelling rationale for its change in position?
No, in terms of the compelling rationale, we concluded that, in fact, neither of these agencies showed any sign of having any meaningful dialogue with Pacificor, and it was surprising to us that was used as the rationale for a change in position when neither agency really had enough of a dialogue to even recall having had the dialogue, one, and two, one of the agencies was totally disengaged, not involved, and had little concern for this, and the other agency was supportive of our effort to extend.
I have no further questions, Your Honor.
Thank you. And just one follow-up from me, and this is really a legal question, so I'll invite your counsel to answer if he deems it appropriate. But you've referenced a couple of times this 45-day expectation of a turnaround time with respect to the feasibility study. Of course, Schedule 38 references the OAT. I didn't see a portion of the OAT quoted, so I went and read it, and where I think what you're referring to is in section 41.3. Can you confirm if that's the case?
I believe that's right, and if you'll give me just a moment,
Sure.
I do have it. And yes, Your Honor, I'm on page 143 of the Open Access Transmission Tariff, FERC Electric Transmission Tariff Volume Number 11 for Pacificor, and it is section 41.3, which says transmission provider shall use reasonable efforts to complete the interconnection feasibility study no later than 45 calendar days after transmission provider receives the fully executed interconnection feasibility study agreement.
Thank you. That's helpful. You're excused, Mr. Ellsworth. Thanks.
Your Honor,
Ms.
that's all we have.
Okay. Ms. Hochul.
Thank you. The company calls Mr. Mark Tourangeau.
before I swear you in, would you mind spelling your last name so I say it correctly?
Certainly. Last name is Tourangeu.
Mr. Toronjo, do you swear to tell the
got
truth? Do you swear to tell the truth, sir?
I do.
Thank you.
Good morning, Mr. Toronjo. Once again, maybe for the reporter, for the benefit of the reporter, can you state and spell your name for the record?
Yes, Mark Tourangeu, Tourangeu.
And by whom are you employed and in what capacity?
I'm employed by Rocky Mountain Power as a director of commercial services, where I oversee our negotiations and relationships with our large industrial customers that we have special contracts with. I also work with customers who are looking to purchase renewables through our green tariffs. And then I also oversee our qualifying facility process under PURPA for the Rocky Mountain Power territory.
And is this the first time that you have testified in the state of Utah?
It is.
And so given that, can you please provide a brief background of your experience?
Certainly. So I have over 20 years of experience in the energy industry. Previous to Rocky Mountain Power, I joined Rocky Mountain Power just about a year ago. Previous to that, I worked for 8 years for NextEra Energy out of Florida, which is the largest renewables owner and developer in North America. I also worked for Morgan Stanley Commodities and for Duke Energy.
Thank you. And are you familiar with the complaint that was filed by Clenera September 22nd, 2017?
I am.
Are you familiar with Rocky Mountain Power's response to that
Yes.
complaint, October 24th, 2017?
Yes,
Did you assist in the preparation of that response?
I did, yes.
And so you're comfortable adopting that response as your own testimony today
Yes, I am.
and responding to the questions about that response?
Correct.
And
Could
you
we
ha-
could we clarify the date on that? Was it 24 or 23?
I believe that was October 23rd, 2017.
That's the date I have.
Thank you.
Do you have any changes that you would like to make to that response?
No, I do not.
So if it pleases the commission at this time, I'd like to enter into the record as Mr. Toronjo's testimony, the company's response filed October 23rd, 2017.
Hearing no objection, it's admitted.
And I'd like that to be marked Rocky Mountain Power Exhibit 1. Mr. Toronjo, are you also familiar with the reply that was filed by Clenera October 24th, 2017?
Yes, I am.
Did you prepare a summary of your response to the complaint and the reply to the company's response that you would like to share today?
I did, yes.
Please proceed.
Thank you. I really just want to make 3 points. The first one is our tariff and procedures in Schedule 38 are very clear that the interconnection process and the PPA indicative pricing and negotiation process are 2 very separate processes. It's mentioned a couple times in Schedule 38. Schedule 38 also provides a directive to QF developers that they should start the interconnection process as soon as possible because it can be a lengthy and time-consuming process. And Pacific Core Transmission Services is the part of the company that runs that process. Pacific Core Merchant, of which I'm a part, is running the PPA contracting process. We, in fact, cannot have communication with Pacific Core Transmission Services due to FERC Code of Conduct rules unless we're granted a waiver by the QF developer. In any case, those processes are very different, very separate, and the tariff is very clear that our customer or our developer who's developing the QF should initiate that interconnection process as soon as possible and typically well before the PPA negotiation process, in which this situation, that really didn't happen. They were really done contemporaneously or actually after the interconnection specifications were corrected by Clenera for Faraday and Goshen. It happened after they had requested indicative pricing. So that is the first point. My second point is due to the tariff, we're unable to start negotiation on a PPA until we have a series of information, a series of facts from the QF developer, including, as Schedule 38 says, their status on their interconnection process. We take that to mean that they need to have established a interconnection date through a feasibility and system impact study done with Pacific Core Transmission Services to be able to prove out that they can interconnect to our system at or about the same time that they anticipate bringing their project to commercial operations. In Clenera's case, Clenera, we are of a mind that given the challenges of taking 1,120 QF megawatts and integrating those onto our system using the approved methodologies that Pacific Core Transmission Services has under our oath to study that, we cannot, in good faith under Schedule 38, negotiate a PPA with them or keep them in our pricing queue until those studies are completed and they can prove that their stated COD date coincides with their potential interconnection date under those studies. The third point is more just goes towards equity overall with respect to all of our customers and stakeholders. Council mentioned it in terms of making sure that the pricing is representative of the COD date when the QF facility is going to come online. I am totally indifferent as to the level of that pricing. It just needs to be right in terms of when that pricing starts, when our indicative pricing starts, has to be associated with the date that that site goes commercial. Otherwise, there's a total mismatch there, and it is not fair to our customers in that the avoided cost pricing is not representative of when the site will actually become commercial and operate for the 15 years it's under contract. It's not fair to other developers who are held to this standard, and it's not fair to all of our other stakeholders as well. So we strive to maintain equity from that perspective, and we feel that the action we have taken, which were very deliberative, we took a lot of time, and I'm the first to admit that, and it could have gone more quickly in terms of our response, but we had a very deliberative process after the conversations with the DPU and OCS, which unfortunately they don't recall it was done in a general sense. It wasn't done with respect to the Clenera situation specifically. Our representative, Kyle Moore, distinctly remembers having the conversations. Unfortunately, the representatives from the Commission and Consumer Services don't. But given that feedback and then a very in-depth analysis that we did over the next few weeks, we feel justified in following our process as defined under Schedule 38 and taking the actions that we took.
I don't have any further questions. Thank you. Or do you have any final comments, Mr. Tarajo?
Yeah, I mean, I struggle sometimes when we talk about the economics, and I don't think we're here to debate the economics of the QF facility and whether it's good or bad for ratepayers. We could have that debate and it could last for hours and hours. This is unprecedented for us to have 14 different QF facilities of 80 megawatts each, basically as one solar development coming onto our system in one location. The impacts on the transmission system are large, and I think our representative from PAC Transmission will speak to that. But the impacts are great, and so you can't really talk about the economic impact just in terms of rates, because there are broad economic impacts across the entire states that we serve associated with this. So we want to make sure we're being very deliberative, very fair with respect to this huge project that is coming online as 14 separate 80 megawatt QF facilities that I'm sure are probably a mile apart. And we want to make sure that we're following our procedures to a T, because this size project will have massive implications for our customers, for fairness, and for our system. And so we want to make sure we're being thoughtful for all of our customers and stakeholders.
Mr. Tarajo is available for questions. Thank you.
Mr. Barkley.
I do have some questions, Your Honor. Good morning, Mr. Toronjo.
Good morning, sir.
Is it your testimony that Rocky Mountain Power has historically required a completed facility study before tendering a form of PPA and beginning negotiations?
My understanding is that we have to have proof that a facility studies has been done that proves that the interconnection can be made at or around the stated COD. Now, I've been here for a year, so I'm not sure if that is always what we followed in the past. But based on our read of the tariff, that's what we're looking at.
Is it your understanding that the tariff requires demonstration that a interconnection study has been completed before you can provide the form of PPA?
Let me pull up the tariff here real quickly so I can speak to that. The tariff says there's evidence that any necessary interconnection studies are underway and that the necessary interconnection arrangements can timely be completed in accordance with Part 2 sufficient for the projects to reach energization by the proposed online date. Our interpretation of that is that until the study is done, there is no way for us to have determined, based on Pacific Transmission Services analysis, whether it can meet its proposed in-service date or not.
And specifically, which study are you speaking of? Are you speaking of the feasibility study, the study impact study, or the final study?
Typically the feasibility study.
Okay. And is it your testimony then that it has been the historical practice of Rocky Mountain Power to require a completed feasibility study before it will tender a form of PPA for negotiation?
Objection asked and answered.
Overruled. I think you reformulated the question slightly. You can answer, sir.
I'm not able to answer for certain historically whether that's been required.
I believe one of the second points you made was a point of equity, and you spoke about fairness to other developers. You do understand, Mr. Toronjo, don't you, that all developers are depending upon the process that's laid out in the company's tariffs in making their investment decision on these very expensive projects?
Yes.
And do you believe that it is the company's obligation to adhere to that process?
I do, yes.
Okay. And you understand that the process that is laid out in Pacificor's open access transmission tariff calls for reasonable efforts to get a feasibility study done within 45 days, correct?
Excuse me, objection, or maybe not, just a clarification. I wonder if that question is not better answered by Mr. Fritz, who will be on the stand shortly.
I'll defer to Mr. Barkley whether you want to reassert the question.
Your Honor, I'd like Mr. Toronjo to answer that because he did opine about fairness to developers and developers' reasonable expectations.
If you know the answer to the question, Mr. Toronjo, you may answer.
Please restate the question.
Sure. Is it your understanding that the company's OATT, Open Access Transmission Tariff, requires that the company use reasonable efforts to complete a facility study within 45 days?
I'm not familiar with the specific term. I believe you read it, so...
Are you familiar with the with the timelines for the remaining two studies, the system impact study and the final study?
I'm not, because I don't work in Pacific Transmission Services.
You mentioned at one point that the company had a very deliberative process. To be clear, the company is still in that very deliberative process, correct?
We've made our decision and communicated it through our response.
When you say your decision, when you referred, maybe I didn't understand your testimony. When you referred to the deliberative process, were you referring to the interconnection study process?
No, not at all. I was referring to the situation at hand here, where we were analyzing our decision as to whether or not to continue keeping the Clenera projects in the pricing queue or not. that is a process I'm referring to that we were deliberating on over time and came to our decision, which we then communicated to Clenera.
Your Honor, I have no further questions.
Thank you. Mr. Jetter.
I do have just a few brief questions. So I'm just going to pick one of the timelines out of Schedule 38 here. So I'm looking at it's Roman numeral 1B4, indicative pricing. And it says, within 30 days following the date a QF project was added to the QF pricing queue under Section 1B3, the company shall provide the QF developer with indicative pricing, etc. Would it be reasonable for the company in that case, if the timeline was 30 days, to come back a year later?
No, it would not.
Okay, that's my only question. Thank you.
Mr. Trudeau. Did I get your name correctly?
Toronjo.
Toronjo.
Toronjo, that's okay.
I just have one question. I'm going to read a couple of sentences from the complainant's initial complaint, and I wonder if you could lend any context to them. It states, on March 13th, 2017, developer made a timely request for a proposed PPA. On March 21st, 2017, the company responded, quote, we have reviewed your request for a proposed PPA, and we find it to be complete, end quote. Nevertheless, nearly a month later, on April 18, 2017, the company requests an additional update on the interconnection studies, asserting it needed to see at least one of the study results prior to issuing a proposed PPA. And I'll end there. Are those statements true?
That is accurate.
And can you explain why the company represented that the application was complete, or that it had all the required information it needed, and later changed its position?
I think that may have just been a case of not having looking at it again and looking at the response with respect to the interconnection study, the feasibility study, and not seeing it there and responding back that we need to see that as well.
All right, I have nothing else. Thank you, sir.
Thank you. Thank you, Your Honor.
Your Honor, I wonder if I can ask a couple of clarifying questions, because I think it's a little bit unclear right now based on what he's testified. Is that okay?
I have no objection.
Okay. Mr. Toronjo, can you testify when the first time it was that Clenera sought indicative pricing or reached out to the commercial unit of Pacific Corp?
I believe they sought indicative pricing in November, and I believe Mr. Shively spoke about that. And then there was a change to the interconnection point, and so that kind of restarted the process. So on December 14th of 2016, they requested indicative pricing for the Faraday 780 megawatt Faraday projects. And then on February 1st of 2017, they sought the indicative pricing for the 780 megawatt Goshen Valley projects.
Is it your understanding that Clenera sought indicative pricing before reaching out to Pacific Corp Transmission regarding the transmission queue and the transmission services for this project?
My understanding of the timeline for the transmission services is, starting in late November, they requested or they applied for a queue number, and then later on in early January, they changed that from just a general large generation interconnect agreement request to a specific qualifying facility request, which would require a network resource application.
Do you have Schedule 38 in front of you?
I do, yes.
Can you please turn to paragraph 3 in the first page?
I'm there.
Can you read for me beginning the generation interconnection process all the way to the end?
The generation interconnection process is a critical and lengthy process that typically must be well underway before a power purchase agreement should be requested. QF developers are strongly encouraged to gain a clear understanding of the transmission interconnection process and associated costs and timelines before requesting indicative pricing or a power purchase agreement under this schedule. The interconnection process is described in Section 2.b of this tariff.
Is it your understanding that Clenera followed this directive?
I think you could question whether they followed that directive.
Thank you. I have no further questions.
I'll allow Mr. Barkley to ask any follow-up questions he may have.
I have no further questions, Your Honor.
Thank you. Mr. Jenner, any follow-up?
No, I don't have any follow-up. Thank you.
Thank you, Your Honor.
Thank you. You're excused. Ms. Hogle.
The company calls Mr. Brian Fritz.
Mr. Fritz, do you swear to tell the truth?
Yes.
Thank you.
Good morning, Mr. Fritz.
Good morning.
Can you please state and spell your name for the record?
Brian Fritz, F-R-I-T-Z.
And by whom are you employed and in what capacity?
Pacific Core as Director of Transmission Services and Transmission Development.
And is this the first time that you've testified in Utah?
Yes.
Given that, can you please provide a brief background of your experience?
Sure. I currently have over 30 years experience in the energy industry with Portland General Electric, Enron, and Pacific Core. My current responsibilities at Pacific Core include general oversight of the generation interconnection process.
Are you familiar with the complaint that was filed by Clenera?
Yes.
Are you familiar with Rocky Mountain Power's response to that complaint filed October 23rd, 2017?
Yes.
Are you familiar with the issues related to the transmission queue that arose in that complaint?
Yes.
So you're comfortable responding to questions related to those issues here today?
Yes.
Are you also familiar with the reply to the company's response filed by Clenera October 24th, 2017?
Yes.
Are you prepared to respond to some of the allegations made in that reply?
Yes.
Do you have any exhibits that support your response to Clenera's reply today?
Yes.
Your Honor, may I approach to provide an exhibit that Rocky Mountain Power would like marked as Rocky Mountain Power Exhibit 2 to the bench and the parties at this time before I continue my direct examination?
Of course.
Thank you. Mr. Fritz, can you briefly describe what I've just passed out and marked as Rocky Mountain Power Exhibit 2?
Yes. What this shows in the top graph is requests that have come into the interconnection queue by size. What you can see is between 2015 and 17, we have seen a large increase in the size of the projects that have been requested in the queue. The bottom graph shows specific to Utah the same information. Again, you can see a very large uptick in 2016.
And Mr. Fritz, just to describe it a little more, how do you compare this graph with what Clenera included in its graphs in its reply to the company's response?
What they provided was just the number of requests, which is just part of the story. What we have here is an additional piece of the story, which has a big impact on the interconnection queue study process.
Thank you. Would it please the commission at this time, I would ask that RMP Exhibit 2 be entered into the record and admitted into evidence.
Any objection? It's admitted.
Thank you. Mr. Fritz, did you prepare a summary of Rocky Mountain Power's response to the transmission queue issues that were
Yes, I
raised
did.
that you would like to give at this time?
Yes.
Please proceed.
Today I'll address the interconnection study process and how the influx of large number of higher megawatt projects in 2016 and 17 have increased the complexity of the process and the time to complete the studies. I'll also address the limited value of bringing on third-party analysts to complete studies. As has been stated today, PacifiCorp follows the FERC open transmission tariff. The FERC Regulatory Commission, they govern the interconnection process, including studies on a non-discriminatory basis. For QF interconnections in Utah, the company's Schedule 38 states that we follow the tariff. We do, as has said today, we do follow a sequential order study process, which is allowed under the tariff, with higher queued requests studied first. This allows the company to determine the system impacts for each generator and associated mitigation, if any. And that's required to ensure that we safely and reliably interconnect each generator and is necessary to properly identify the project that is triggering any system improvements and then to incorporate those improvements into the study results for that project and any lower queued projects. Contrary to Clenera's claim, the time required to study generator interconnections is not simply a function of how many are in the queue. That's a small piece of it. More important factors include the size, where the interconnections are proposed, if they're on transmission or distribution, and the activity in the higher queued projects. And what I mean by that is if projects higher queue are removed from the queue. So what we see in Exhibit 2 is it demonstrates that in recent years we've seen a large increase in the size of the projects. And they've been on the transmission system and not the distribution system, as is Clenera's request. There's a significant difference between studying a project such as a 3 megawatt project on distribution versus a 1,050 megawatt project such as Clenera's on the transmission system. And these factors will increase the complexity of the study and the timeline required to do those studies. Another complexity is in the process, since we use a sequential process, if a higher queued project removes from the queue, we're required to then go back and restudy lower queued projects to look at the impacts that were identified with the higher queued and do they apply to the lower queued projects. And then we would apply those to the lower queued projects. So right now, the company is experiencing an unprecedented spike in interconnection requests of large megawatts. You can see, again, you can see the spike in Exhibit 2. We currently have more megawatts in our interconnection queue than we have existing generation today. And it is approximately a 200% increase in excess of current Pacificor East network load. As an example, this single 1,050 megawatt project that Clenera is proposing equals approximately 1/10 of Pacificor's existing generation fleet. The interconnection study process uses a complex power flow model to determine impacts to the system and upgrades required to maintain reliability of the system. As proposed, generation increases at a pace faster than load, which we are currently experiencing. The analysis becomes increasingly complex. With a request of this size, 1,050 megawatts connected at the same point, the impacts are likely to be identified across a very wide footprint of Pacificor's transmission system. This also increases the complexity. The value of independent third-party interconnection study is limited at best. An independent party only has access to publicly available information, and not all interconnection studies are public. There's also information about Pacificor's transmission system that is not publicly available. Therefore, the independent third-party analyst does not have sufficient information to complete an appropriate interconnection study. Simply focusing on one project does not provide the information required and could jeopardize reliability of the system. So in summary, the process schedule is impacted by the size, location, if it's proposed to interconnect to transmission or distribution, and the action of those projects that are higher in the queue. The use of third-party analysis does not provide the full picture and cannot be used effectively by picking one request in the queue and performing an analysis without the full information of all higher queued projects.
Mr. Fritz, just maybe one or two questions. Is Pacificorp Transmission processing interconnection request applications as quickly as possible given the sequential process it uses and the complexity of the process, including as well the number and the size of the projects that are seeking requests?
Yes, we're using all reasonable efforts, as is stated in the tariff, to complete these studies in a timely manner.
Thank you. Mr. Fritz is available for questions.
Mr. Barkley?
Good morning.
Excuse me. Is it the historic practice of Rocky Mountain Power or Pacificor to require a completed feasibility study before tendering a form of PPA for negotiation?
I can't answer that. I am not part of the marketing function. I don't deal with PPAs. What I can say and what I heard earlier is that is the case.
You are not personally able to provide us today an example of an instance in which either Rocky Mountain Power or Pacificor has required a completed feasibility study before tendering a PPA. Is that correct?
That is correct.
Regarding the chart that you supplied, what was the source of the data for this chart?
It's the data that is in our interconnection queue.
Is that data from your Oasis system?
I would have to go look at Oasis and see if we actually provide the megawatt information in the queue information that we provide.
If that's not provided, would that likely be because of confidentiality concerns?
Yes.
Would you expect this information to be otherwise consistent with the data that's in the Oasis system?
Yes, if it's provided.
I believe you stated that you were familiar with the October 23rd response that was filed by Pacificor, correct?
Correct.
And is it your recollection that in discussing the workload facing Pacificor, that October 23rd response focused on the number of interconnection requests or on the magnitude of those requests?
Reading the document, it focused on the number, which, as I've stated, really doesn't provide the whole picture.
Now, one of the difficulties that you discussed was the difficulty of having to deal with changes ahead of an applicant in the queue.
Yes.
Did I word that well enough for you to understand?
Yes, you're talking about a higher queued project that would remove itself or get removed from the queue.
And that's a significant problem?
It's a consistent problem. We recently have seen 2 very large projects removed from the queue in southern Utah, which will have impact on the other projects in the queue.
Is that more likely to be a problem when there are 2 applicants or when there are 20 applicants?
It's more likely to be an issue based on all factors, not just the number. Again, we see people remove themselves from the queue for various reasons. I think a consistent reason is with these larger projects, the cost to integrate them to the system is sometimes very large. And I would assume that then drives their economics the wrong way and they remove themselves from the queue. So I would say it's probably more a function. It's not just a function of number, it's a function of number and size and location.
But to be clear, if there are 3 requests in the queue and I'm number 3, there are only 2 people ahead of me who might change their minds and affect my timing, correct?
No, it's not just that there's 2 people ahead of you. It's how many are ahead of you that may or do remove themselves from the queue that then have an impact on you. And so that project could be in southern Utah, northern Utah, Idaho. If it has an impact on those queue positions below it, then those queue positions have to be restudied to evaluate the impacts and the upgrades associated with that removed project, and those get applied down into the queue.
Maybe my question wasn't clear because I'm not sure your answer was inconsistent with what I was suggesting. So let me try again. If there are only 3 applicants in the queue and I'm last, I'm number 3, there are 2 applicants in front of me, and if either of those 2 applicants decides to withdraw from the queue or change the parameters of their application, that could affect me, right?
Yes. In theory, if there were only 3 customers in the queue in the same general location or in a location that would impact you if they remove themselves, yes.
And if there are 40 applications in the queue, and again, I have the misfortune of being last, I'm number 40, there are 39 applications in the queue ahead of me, any one of which could change, either withdraw from the queue or change its parameters and require a restudy that would affect me, right?
That is possible, yes.
And is it reasonable to suggest that if there are 40 applications in the queue, it's more likely that some of them are in the same area or region as I am, and some of them may be on the same transmission lines I am?
It's possible.
Is it your position today that the Rocky Mountain power tariffs and or the Pacificor tariffs do not allow for a cluster study of the sort that was described by Mr. Ellsworth?
No. A cluster study or sequential studies are both allowed in the open access transmission tariff.
One last topic, Mr. Fritz. In the company's October 23rd response, there was a reference made to docket number 17-35-13, in which Pacificor Transmission had experienced an unprecedented surge in interconnection applications. You familiar with that reference?
Yes.
It is correct, isn't it, that in that docket, Pacificor cited its workload as support for a request to extend deadlines?
Yes.
Thank you. I have no further questions.
Mr. Jetter?
I do have a few questions. Good morning.
Good morning.
I guess let's start out with when did the PacTrans unit realize that it was seeing a sufficient volume of applications coming in that it was no longer able to keep to the 45-day turnaround on those?
I don't have exact dates in front of me, but it would have been in, I believe, late 2015, early 2016.
And do you notify QF applications immediately upon their application to you for an interconnection study that this is the case?
No, not immediately.
At what point in the process do you typically notify them?
When we get an application in, there's many steps we go through, but when we get a deemed complete application, then we hold a scoping meeting. When we have the scoping meeting, that's where we would provide information on the study process.
Okay. And so would it be fair to say that there's really no way for a QF to know what the timeline would be before they get to that point?
Again, I would have to go back and look and see what information we have in the on Oasis. I'm trying to remember if the dates are included there or not, but that could be a way for them to see that.
Okay, and in this case, do you know when that scoping meeting happened?
The scoping meeting was January 3rd, 2017.
Okay, and do you know how soon after that you had informed the applicant for these QFs that study would be delayed?
That would have been 3/14/2017.
Okay. Thank you. Since the influx of these QF applications in 2015, has the staff that do the calculations and the studies on this been increased at PacTrans?
First, I'd like to clarify that it's not just an increase in QFs. we don't treat the QF requests any different than we do a FERC jurisdictional request. They enter the same queue and they're studied in the same manner. We have added a consultant to help with the studies during this time frame.
Okay, and when you say a consultant, is that a consulting firm or is that an individual person?
It's a consulting firm.
Okay. Has that significantly reduced the time to turn around these applications?
Initially, yes, it did. With the additional influx with the size, it hasn't gone as fast. When we first brought them in, we were dealing more with small generation, and so it's. I would say it's helped, but it's slowed down a little bit.
Okay, and is it accurate to say that a new application today, if we hypothetically created a 80 megawatt new QF at the bottom of the queue in the same location of southern Utah, they would be reasonable to expect a 1 year plus time frame?
Yes.
Are you doing anything actively now to reduce those times?
Not beyond what we've done. We have looked at options. We have not found an option.
I guess maybe to follow up on that, could you briefly describe what options you've considered?
We've looked at options of breaking the system up. In other words, looking at studies associated with southern Utah, eastern Wyoming. What we have found is that with the increase in the megawatt size, that doesn't work. We've looked to see if there's additional contractors out there that could help. And we have looked at adding resources, although we've only looked at that. We haven't done any real analysis or decided to do it.
And in terms of these studies, if you were to increase your staff doing the studies, would that speed up the process?
No.
And why is that?
Because we use the sequential method, so the higher queued project has to be studied first. And so throwing bodies at the queue doesn't necessarily mean that you speed the process up.
So in that sequential study, is it computer calculation time? What is taking so long that adding another team of analysts would not speed that up?
Generally, it's the complexity of the analysis. And so when we see this, increase in size and megawatts in the requests, it involves a larger footprint of the transmission system that has to be analyzed. And so with the power flow analysis, what we're really trying to do is, at the end of the day, balance generation with load. So as your generation increases beyond what your load increases, then it becomes more and more complex. It takes more time to do the study. We use a term in the power flow analysis that we say the analysis has to solve. And that means that we have figured out what additions need to be made, what are the impacts, what are the solutions to those impacts, that we maintain a safe, reliable system for all customers.
And so in doing that, you're using, I assume, a model of your current grid
Yes.
of transmission lines
Yes.
and the distribution system. Is that right?
Yes.
And the calculations done on the power flow across any given line, are those generated through a computer model, or are you doing some type of a manual input calculation?
It's a computer model, but there's a lot of human interface when it starts coming to the time of the model didn't solve. Now, how do we fix it so it does solve? And so that requires pretty good knowledge of our system to be able to do that. And what I mean by that is if it doesn't solve, then what the engineering planner does is says, okay, well, what if we install X? And that could be a new transformer, it could be a phase shifter, it could be a new transmission line. And does that solve the case? And of course, when they do that, then that has more impacts on the rest of the system, so they have to look at it again.
And you just do one test solution at a time and see if it works, and then go on to the next one.
Yes, I
Okay.
believe so, although I'm not a planner.
And I guess ultimately my question is, as a regulator from the state of Utah, what we're seeing is potentially putting customers at risk of delaying good projects or potentially causing good projects to be terminated simply by a delay in the calculations or the analysis from PAC-Trans. And frankly, that's kind of why we're here today. Is it accurate to state that your testimony is that there's nothing you can do to speed this up?
No. We continue to look for ways to speed the process up. And that does include, the possibility of moving to a cluster type study. But these are things that, sorry to say, can't happen overnight.
Okay. I think that's all of my questions. Thank you.
Thank you.
I have a couple. Do you want to wait or go ahead and do your redirect?
I apologize. I will leave that up to you, whatever you want me to do, if you want me to go
Go
before or after. Okay, thank you. Mr. Fritz, to your knowledge, does the OAT allow for reasonable delays in the processing of interconnection application requests to accommodate spikes such as spikes in the requests, such as the surge and the spike that Pacific Corp Transmission is experiencing and has been experiencing for over a year now?
Yes.
Okay. You were also asked earlier about the cluster process and whether that is allowed under Pacific Corp's OAT. Do you recall that question?
Yes, I do.
Is it your understanding whether this hearing is to debate our process, or is it to find out whether Pacific Corp is following its Schedule 38 in order to run through the applications pursuant to Schedule 38?
It's my understanding that this hearing is about how Pacific Corp is following Schedule 38.
Could one of the reasons or a factor that is driving this surge in the applications interconnection requests be the upcoming expiration of the PTCs? Is that a factor perhaps that is driving the significant surge that the Pacific Corp Transmission is seeing with its interconnection requests?
Yes, actually, that's a phenomena that we see every year that we get close to, that date, and it has happened in various times in past history, and when that, we start getting close to that date, we see an uptick.
Does Pacific Corp Transmission have control over the number and the size of interconnection requests it receives?
No.
You were also asked about whether you understood that as regulators, these delays that are caused by the significant number and volume of requests that Pacific Corp Transmission is getting could potentially be harmful to customers. Is it your understanding that as a regulator also running through these applications without the sequential process that is used by Pacific Corp and without following Schedule 38 could also potentially be harmful to customers?
Yes. By not following our process, if we were to pull a customer out of that process and study them outside the process, then that would harm everybody with a higher queued project, or I should say has the potential to.
Is Clenera to your knowledge, the only QF that is experiencing these conditions in the current environment of ever increasing requests as a result of the PTC's expirations?
No, I would say that that's an issue with every applicant in the queue. It's not specific to QFs or FERC jurisdictional. It's the timeline in the queue today, and it impacts everybody in the queue.
I have no further questions. Thank you.
Your Honor, could I be permitted just a couple of quick follow-ups to that?
Of course.
I want to talk specifically about your statement that the utility, by which I assume you mean PacTran, has no control over the number of applications. In looking at your chart, what was the date, by the way, of this data?
Yesterday.
Yesterday. Okay. Has Rocky Mountain Power recently issued an RFP for proposed projects?
Yes, I believe they have actually issued 2.
Okay. And so that is an invitation for people to propose new projects that will have to be studied, correct?
I'm not privy to the details of the RFP, but I believe it's my understanding that a developer has to be in the queue before they can submit a project in the RFP.
So if I want to respond to the RFP, I've got to get in the queue before I can do so.
I believe that's correct, although maybe Mark has a different take on that.
You also said that it was your understanding that the OATT allows for reasonable delays due to spikes in applications. Are you able here today to point us to the language in the OAT or the general area where we would find that?
You pointed it out earlier when you quoted the 45 days. It says reasonable effort.
Okay. Perfect. Thank you. That's all I have.
Thank you. And just a couple of questions from me, Mr. Fritz. I believe you testified earlier that your understanding is that the OAT allows PacTran's discretion as to whether to employ what we've referred to here today as a serial method or a cluster method. Is that right?
Correct.
Whichever option PacTrans selects, whether cluster or serial, does the OAT require PacTrans to apply that method to all applicants?
I would say that the tariff is not clear on that. The tariff allows you to use either process. I don't believe it's clear on exactly how you apply the process and if you can split it up.
Okay. So you don't know the answer to the question as to whether, if this commission issued an order finding that PacTrans ought to use the cluster method, that PacTrans would be in violation of its OAT if it did not employ that method in FERC jurisdictional applications.
I don't think I have an answer to that.
Okay.
We're allowed to use cluster studies per the tariff. So I don't think I can answer that if we were directed.
No, that's fine. I don't know is a perfectly acceptable answer. Just wondering. Have you testified in other administrative proceedings, whether before a state commission or before FERC, that related to PAC-Trans's processing of interconnection applications or the studies related to them, and specifically the timeliness of that processing?
No.
I have nothing else. Thank you. Ms. Ogle.
The company rests its case. Thank you.
Thank you. It has been, well, I was going to point out it's been a little over 2 hours, and the parties might desire a break, but it looked as though Mr. Barkley wanted to say something.
I want to be sure that whoever needs my certificate of good standing gets it, because it's really pretty, and I worked hard to get it.
Okay.
But other than that, we're fine.
I assume Mr. Jetter wants to put on some evidence. Is that correct?
Yes.
Would the parties like to take a break or press on?
I'm fine
Maybe
with
a
pressing
5-minute
on.
break. I think
Hearing a request for a break, I think we'll allow it.
Sure.
We'll be back at 11:20 in 10 minutes. We're in recess. Thank you. Go back on the record, please. Mr. Jetter?
Thank you. The division would like to call Charles Peterson.
Mr. Peterson, do you swear to tell the truth?
Yes.
Thank you.
Mr. Peterson, would you please state your name and occupation for the record?
Charles E. Peterson, spelled with an S-O-N.
Thank you. And
My occupation, I'm sorry. I'm a utility technical consultant with the Division of Public Utilities.
thank you. And in the course of your employment, did you have the opportunity to review the filings in this docket?
Yes.
And did you create and cause to be filed with the commission an action request response dated October 23rd, 2017?
Yes.
Do you have any corrections or changes that you would like to make to anything you've put in that document?
None that I'm aware of.
And rather than going through all of that with you today, would you adopt that as your testimony?
Yes.
Thank you. I guess I'd like to move at this point to enter the action request response of October 23rd, 2017 into the record.
It's admitted.
Thank you. Just a couple of brief, maybe follow-up questions from things that have been discussed this morning. Would you tell me your thoughts on the use of the I'm not remembering the correct term, the group study method rather than sequential method? Do you think that, to be more specific, do you think that a wholesale switch to that type of method would be possibly more appropriate after a broader docket to evaluate whether that's the appropriate method for the commission to order?
I think in a regulatory process, that would be the proper procedure, to have a separate docket that would study the pros and cons of each method and allow different parties to weigh in from an engineering standpoint or technical standpoint, as opposed to someone like me and an economist to opine about it.
Thank you. I have no further questions. With that, Mr. Peterson's available for a cross of the parties or questions from the commission.
Mr. Barkley?
I have no questions. Thank you, Mr. Peterson.
Okay. Ms. Hogel?
I have no questions. Thank you.
I suppose I just have one. If you could summarize the division's recommendation as to what the commission ought to do with respect to any ordered issues in this proceeding, that would be helpful.
Well, I think the division's position is outlined in the memorandum or action request response that we followed, but basically the division believes that delays in the timeline created by the company, which would also include PAC-TRAN, are a basis for extending or suspending the timeline in a given case-by-case situation. It appears to me that Clenera was operating under the assumption that Pacific Corp was going to be able to function at or near its tariff timelines when it began the process. That by the end of March, it appears that by the end of March, Clenera clearly understood that March of 2017, to be more clear, the company was not going to be able to process its interconnection requests for almost another year. The division leaves open the question whether the company is acting reasonably in processing its interconnection request, but we know that this has become a problem and was part of the subject of a previous docket before the commission. So the division thinks it's reasonable, believes it's reasonable, and recommends that the commission give essentially a day-by-day extension until such time as the company provides a interconnection study to Clenera, at which time the clock could be restarted.
Perhaps I should have been more specific. Does the division also concur that the commission should grant that day-for-day extension with respect to the commercial operation date?
No, the division does not go that far.
All right. I have nothing else. Thank you, Mr. Peterson.
Thank you.
If any council wishes to make any closing statement or argument, I'm happy to hear it.
Your Honor, can I take care of one housekeeping item first? Me. I should probably offer Clenera's complaint as Exhibit 1 and their October 24th response to the motion to dismiss as Exhibit 2.
Hearing no objection, they're admitted. Thank you. Are you interested in making a closing statement or argument?
I'll make a very brief one, Your Honor, and thank you for the opportunity.
I'm sorry, Mr. Peterson, you can take your seat.
Thank you, Mr. Peterson. Clenera's position is that they should not only be expected to be familiar with the utilities procedures and processes as they are laid out in the company's tariffs, but they should also be able to rely upon them. The company is way outside the deadlines that are stated in those tariffs. An initial step, which was to take 45 days, is currently taken, by anybody's reckoning, over 200. And we are still months away from the projected target for that initial step. There are 2 steps after that that traditionally take 90 days, adding another 180 to that. And the company's feedback to Clenera on the adequacy of the information provided has been inconsistent. As I think you noted, there have been times at which they've been told they had done everything they needed to do, only to be told subsequently that, well, it turns out that's really not enough, we need something else. Certainly the company is allowed delay, but it is required to make reasonable efforts. And I think as we listen to the testimony today, it's pretty clear that there have not been reasonable efforts. In fact, the testimony today from company witnesses was that they can anticipate spikes anytime the PTC is up for renewal. So this was, by their testimony, something they could have anticipated. The testimony was that they have no control over applications, but in fact, they and their affiliates issue RFPs that do in fact have an impact on the level of applications, and they should have some insight into when and how that's going to happen. And lastly, I'd just say that the extension of the operational date deadline is critical. There is a limit on how far out an applicant is allowed to push that deadline, that operational date, in their initial application. And given that limitation at the outside, if the company is allowed to delay its studies this long, they have the ability to effectively kill a project. And developers should not be in a position where they're caught in that pincer. They need to request PPAs early enough that they can get through the negotiation and get it executed in time to then meet their operation date. Because if the operation date comes more than 3 months too early, they can be kicked out of the queue and lose their pricing. On the other hand, if they're subject to these kinds of delays, they get pinched from the other direction. So they're put in something of an untenable position. I think, as Mr. Ellsworth indicated, I think the company would be open to some sort of modification if it involves redoing the study for year 16. I think, frankly, if it involved shortening the term of the PPA by a year in order to account for those delays. Those are all things that they would be open to, and that would leave consumers, frankly, in no worse position than they would have been in, but preserves the investment decisions that were reasonably made by Clenera. And thank you, Your Honor, for your time.
Thank you, sir. Ms. Hogle.
Thank you, Your Honor. Rocky Mountain Power Pacific Corp. Its goal is not to kill any projects. It has nothing against Clenera QFs. However, I do think that the evidence today has shown, contrary to what has been testified by Clenera and its witnesses, that Rocky Mountain Power is facing an unprecedented number of interconnection requests. One of the factors that is driving that is the PTC upcoming expiration. Unfortunately, the decision of Clenera to reach out to Pacific Corp Merchant, or our commercial unit, to seek indicative pricing before going to Pacific Corp's transmission unit to familiarize itself and educate itself about the transmission queue and transmission process at that time, I think, is the reason why we are here. I think a couple of key points that need to be made again here, and that is that the QF pricing queue is managed by Pacific Corp's commercial unit Merchant. It's independent and separate from the interconnection transmission queue and service maintained by Pacific Corp's transmission unit in accordance with the OAT, which has been generally adopted by this commission. The interconnection queue and process is critical and lengthy and should be well underway before seeking indicative pricing and a power purchase agreement with Pacific Corp's commercial unit. That is one of the very first things that is included in Schedule 38, Paragraph 3, under the preface section. Developers are strongly encouraged to gain a clear understanding of that process before reaching out to Pacific Corp's commercial unit for indicative pricing. That did not happen in this case. This is particularly important in the situation that we're in currently with the significant surge in applications that we have been seeing, Your Honor. Again, the company has nothing against Clenera. If the commission in its discretion believes that extenuating circumstances exist for it to allow Clenera to stay in the queue, Pacific Corp is ready to accept that. However, we also want to remind the commission and for it to be mindful that there are situations that this is not a unique situation. This situation is similar, or other QFs are facing similar situations. And so whatever decision it makes in this particular case, although would not apply to other QFs, certainly informs the company and the way that it handles future QFs. And the decision that the commission makes will affect its customers, will affect Pacific Corp's customers, retail customers in particular. Let me make sure that there was also some discussion about the cluster process using the cluster process as opposed to the current process that Pacific Corp Transmission uses. And I believe that Your Honor even asked a question regarding that. I suppose in closing, Pacific, I would submit to you that that is not a decision that can be made independent in a vacuum from the processes that are used by Pacific Corp. I believe that's even going into FERC jurisdictional law. That has to be studied. It will impact the reliability of the system. Pacific Corp has been using its current method for a long time, and something like that, a decision to use the cluster method, requires that issue to be taken in Pacific Corp's mind, or it is Pacific Corp's position that that is something that needs to be taken up in a broader scale and studied so that there are no unintended consequences. Thank you.
Of course, and I'll just iterate to clarify and perhaps alleviate any anxiety. My question wasn't intended to suggest that this would be an appropriate proceeding in which to make such an order. I'm wondering if even basing a finding in this case that assumed such an order would be appropriate in the future, would be a legitimate basis for finding in this case. In other words, we've heard testimony that a cluster method would be more efficient, but if that's not an option for this commission to order at any time in the future, then it's difficult for me to understand how it would be relevant to consider in this case. Mr. Jetter.
Thank you. I'll keep our comments brief. I wanted to clarify a few things that, particularly we'll start out with the division's position on the delay of the commercial online date. The division has fairly consistently, throughout the history of the QF process, and we've gone through a number of dockets to hopefully fix some problems in the pricing, and we've been often concerned about stale pricing and online dates that are far off into the future, which result in putting customers at risk in those scenarios. In this case, the division is not recommending a day-for-day extension of the commercial online date, but I wanted to clarify that the division is not opposed to some deviation of the commercial online date. I think, at least at this point, we're not sure how much additional time or if additional time is actually necessary, depending on how the next set of studies go and how this project goes through the PPA negotiation process and what comes forth after this. And so I suppose our recommendation might be something along the lines of that we wouldn't oppose a extension or the possibility of an extension to be determined. What we would be concerned about is the potential for a day-for-day extension that ends up extending that commercial online date 6 months past where it needed to be to have the completed project done and online. And so ultimately our goal would be, if these go forward, that we match the commercial online date as nearly as practically possible with the dates that the avoided cost calculation were performed over. I hope that gives a little bit of clarity to where our opinion or our recommendation would be on that. And I think we've covered most of the other comments from the division in our pre-filed comments by Mr. Peterson. So I think that would wrap up my closing statement. Thank you.
All right. I thank the parties for their participation. Happy holidays.